Yes, Mr. Harrell.
My Lord, I appear on behalf of the appellant in this matter. I have the assistance of Miss Sian McGibbon, Mr. Kyle Taklal Singh, Mr. Stefan Ramkisoon, and Miss Ria Khan. I should say that Mr. Ramkisoon and Miss Khan make their first appearance before the board in this.
You're both very welcome.
Very grateful. My Lord, if I can come straight to it, this appeal essentially concerns a point of statutory interpretation.
Yes.
Arising from the Public Assistance Act, which makes provision for a disability assistance grant. In short, what we say is that there is no requirement of permanent disability in being able to access that grant, and that permanent disability not being a requirement under the Act, it should not have been so construed by the Court of Appeal. We also say that such statutory criteria that did apply, the appellant Ruth Peters would have satisfied at the time she made her application. It is not understood that there's any dispute that she was so disabled that she was unable to earn a living. So the only question the board needs to resolve is whether there is this distinction between permanent and temporary disability as the Court of Appeal thought. The appellant suffered from, and I think still suffers from, Guillain-Barré syndrome. We took some instructions this morning. We understand that she still has the use of a wheelchair, so that is the most up-to-date position we can give. There is unfortunately no definition of disability in the Act, but it does appear that the respondent accepted that it would at least include some forms of long-term impairment, and it's a very small point, my lords, but it may be worth looking at. Can I invite the board to page 112 of the electronic bundle? And it's at the bottom of that page, grounds of appeal, specifically Roman numeral 2. It's 112.
Did you say the bottom?
It's towards the bottom of page 112, and it's grounds of appeal 3 Roman numeral 2.
Yes.
And this was the respondent's appeal to the Court of Appeal. And what they said is that the learned judge erred in rejecting the construction of the term disability assistance grant to cover forms of impairment that are long-term or permanent. We emphasize that phrase long-term. And what we say is that it appears that the respondent was at least prepared to acknowledge that the disability assistance grant could cover people who are long-term disabled. And as such, there is no reason why the appellant's condition should, in this case, have been seen as temporary. But in any event, what we say is that this ground of appeal demonstrates the problem in a welfare officer preventing the local board from considering an application by making a summary decision that the disability has to be permanent and therefore the appellant did not qualify. The board will have seen from the evidence in the case, these are the relevant medical certificates that the appellant had to fill out, that what it says is that she is disabled from earning a living, that she was 90% disabled, and thirdly, that the period of disability, not that it would be 1 year, but it would be 1 year pending clinical review. So there was no suggestion that the condition would not persist or be long-term, merely that there would have to be a review within, at the end of 1 year. And so what we say, my lords, is that in this particular case, there can't be any doubt that disability, as used in the Act, does not include a requirement that that disability be temporary or permanent. It simply cannot be reviewed in those terms. There's also something that may be of assistance. Although there's no definition of disability in the Act, and I know that the Court of Appeal placed tremendous weight on Hansard, but again, easy to overlook. If the board looks at page 1062 of the bundle,
yes,
you will see towards the middle of the page, headed Persons with Disabilities, in brackets, International Day. This was the minister in charge of the department at the material time, who's the first respondent in this appeal. And if you look at the second
Sorry, when
paragraph...
you say at the material time, there are several times which are potentially material. What date?
Well, I'm so sorry. At the time this debate took place, so this is 1998.
What date in 1998?
This was the 4th of December 1998. And the reason we draw this to your attention is that although there's no definition in the Act, what the Minister said in the second paragraph is this: Mr. Speaker, first of all, I would like to define the term disability, which according to the United Nations is any restriction or lack resulting from an impairment or inability to perform an activity in the manner or within the range considered normal for a human being. The reason we say that that may be of some significance is the Senator who spoke later, Senator Brian K. Tong, upon whom the Court of Appeal relied in relying on what he said in Hansard, did not contradict this definition as offered. And because disability is not defined in the Act, we say that it cannot be doubted, particularly having regard to how disability was viewed both then and how it should be viewed now, that there was any requirement for permanent disability.
But the context of this,
yes,
there wasn't any reference here to the provisions of the Acts that
correct.
we're talking about.
Correct.
This is just a general proposition about disability.
Yes, it is. But the reason we say it's worth looking at is because immediately after this, that's when we have the introduction of the amendment by Senator Kai Tong. My Lords, ultimately what we seek in the appeal is restoration of the judge's judgment, which we say struck the correct balance in resolving the conflict, if there was any, between the regulations and the Act. And so can I, with that brief introduction, can I take you to the Act, which is at page 465 of the bundle? Now, my Lords, this is the relevant extract. It's 11A subsection 1D. And we say that this is both the start point and end point.
And so the date this was introduced by way of amendment was?
This was introduced in 1998.
And what date did it come into force?
I'll have to check that, my Lord, but this was the provision in force at the time of Ruth Peters' application. But we'll get the date for my Lords.
So after the 1997 regulations were made?
Yes. Yes. There have been various amendments, as my Lords may spot from the left-hand margin record, but not material for the purposes of the argument we're going to make. But what we say is that all that is required, as per the Act, is that, in the opinion of the local board, the candidate applying is so disabled that they are unable to earn a livelihood and has been certified by a medical officer as being so disabled. There is no requirement for permanent disability. It also makes clear...
Sorry, just before we move on from that.
Yes.
Going back to Lord Stevens' question, as I understand it, no new regulations were introduced alongside this amendment of the Act, is that
Correct.
right?
Correct. There were amendments to the regulations subsequently, but not in relation to...
So would it be fair to say that this Act is to be construed in light of the existing regulations? There was never any manifestation of an intention to change those regulations?
Well, we would say that the Act, insofar as it's in conflict with the regulations, we're going to take the board to the relevant legal provisions that support this, that the regulations have to give way to what is stated here in the Act.
Right, but I follow that as a submission, but in construing the Act itself, might it not be said that it's part of the material context that there is already a set of regulations, no suggestion that they will be changed, so that the intention in relation to this Act is that it should operate alongside and in the context of those regulations?
Certainly I would accept, my lord, that both the regulations and the Act as amended have to operate alongside each other, subject to the argument we make that, in fact, the Act trumps the regulations if there is any conflict, and we feel confident we'll be able to demonstrate that.
But I think that my Lord Sale's point was, in construing the Act to see whether there is any conflict, can you not take into account that they weren't intending to change the regulations?
We would say the answer is no, but I recognise that if you haven't changed the regulations at the same time you're changing the Act, there may be an argument that you have to construe one with the other. But what we say is that there are other provisions which, as I say, I'm going to take the board to, that demonstrate that, in fact, you wouldn't treat the regulations, even if they're not amended, as altering the terms of the Act as amended.
Do you accept that the regulations were validly made under the Act prior to its amendment?
Prior to its amendment, yes.
Yeah. They were within the scope of the power?
Yes, prior to amendment. But what we say is...
Sorry, just to, so we're all clear, this is perhaps a curiosity of this case, that as I understand it, both the forms and what it was said in the Act were in full alignment down to from 1996 to 1998.
Yes, prior to the amendment, because there was a provision in the Act that used the phrase permanent disability. Right. That was removed from the Act.
So there could be no question but that the regulations were intra vires at the time that they were.
At the time, yes.
And indeed, down to the point when this Act comes into effect.
Yes.
Because it's only at that point that you say you have your argument that
Correct.
This Act...
Correct. We're not suggesting that at the time...
Virus.
Yes, I'm sorry, I spoke over my lord.
No.
But we're not suggesting that at the time the regulations were made, when the Act and the regulations are in alignment, there is any conflict. I should also say that we did... the point was made by Mr. Takdal Singh in the court below that there was a failure to amend the regulations at the time this amendment to the Act was made. But as I said, we say that it can be resolved in any event. My Lord, absent a definition of disability in the Act, we say that there is nothing in the Act that meaningfully draws any distinction between temporary and permanent disability. And that's not surprising, my Lord, because it is possible for someone to be long-term disabled. You simply cannot look at it, as we say the Court of Appeal tried to look at it, in terms of the concept of temporary and permanent disability. Disability doesn't work like that. It is not the condition or illness the person suffers from. It is, in fact, the effect on that person on their ability to work in the context of this provision. My Lord, it's worthwhile...
I apologise, sorry.
I'm so sorry.
Firing questions at you, but you say there's nothing in the Act that indicates the necessity for a degree of permanence. But how about subsection 4?
This is a person who's paid disability assistance. Well, we're going to come to deal with it. We don't say that that can be construed in terms of permanent disability. It really only looks at whether you're so disabled that you cannot earn a livelihood, whether that is a condition that lasts a year, 2 years, 3 years, or 5 years, you would still fulfill the criteria. We know that the Court of Appeal relied on this provision to suggest that there was some sort of ambiguity. But as I say, we will indicate that actually there is no ambiguity. This does not say, even when you read it, that there has to be permanent disability in any event. It simply says that a person who is paid disability assistance would continue to receive it as long as they fulfill these conditions. But that's also predicated on another point that the Court of Appeal made, that there can be no review, or there's no requirement for a review. Again, we will demonstrate that that's not right, and it would be extraordinary if there couldn't be a review, bearing in mind this is dispensation of public funds.
It would be extraordinary if it wasn't permanent.
Well, it would be, but, for example, even if someone, and you could use the label is permanently disabled, and they would, on the information available, qualify for long-term disability assistance, there would still need to be some review from time to time to see that they still fulfill the criteria. And I'm going to come on to this now, if I may. If I can invite the board to look, please, at the definition, the interpretation section of the Act. I'm trying to keep this chronological to assist the board. This is at page 461, section 2. And this is the definition of public assistance, the very last definition in this section.
And can I just check?
Yes.
Is this the definition section as from, well, this looks like 1951, so I was just trying to see.
There was an amendment to introduce disability assistance. So the margin note tells me that in 1996 and 2003 there was amendment to this section. But public assistance, insofar as it may have been amended, would have to have been amended from the 51 ordinance because they introduced disability assistance as a separate type of award.
So is this definition provision effective as at 1996 with the changes that came in?
Yes, we would say that it is, because by that time disability assistance had now been introduced. But taking the board to the definition, public assistance means relief granted to a person in accordance with this Act and, unless the context otherwise requires, includes disability assistance provided for under this Act. So the approach, my Lord, is that public assistance, insofar as it's referred to throughout the Act and we say the regulations, includes disability assistance unless there is a reason to draw a distinction. And coming, I hope, to what my Lord Stevens was asking me about 11.4, can I take the board to section 10, which is at page 464. And what we say in relation to this is that section 10, subsection A, is of significance because it puts the duty on the local board to inquire not just into the circumstances of an applicant, but also a recipient. Subsection D is also significant because it emphasizes the duty to keep its accounts. Now, the reason we draw those two particular provisions to the board's attention is that if the board has a duty to inquire into recipients and a duty to keep accounts, it's going to be rather difficult to do that if there's no review. And so that's the strongest indicator that a review, even of disability assistance, is required. And there is nothing in this section that excludes disability assistance from its ambit.
But it must be the relevant circumstances of every recipient.
Yes.
And why would the extent of relevant circumstances not be controlled by section 10A4, isn't it?
Yeah. 11A4,
forgive me. Because it is express about a right of someone who is a recipient to go on being a recipient.
Yes, except that if conditions change, how is the local board to know? Unless they carry out a review. And we say that, again, I'll get to
that, but how can they, in relation to a particular recipient under 11A, how can they look at anything other than what subsection 4 says they've got to look at?
Well, my Lord, that we haven't come on to the regulations yet, but the public assistance regulations, regulation 3.2, which we say applies to all public assistance, indicates a review, I think, every 12 months. And so we say that that would be, even if it is simply an inquiry to be made that the person fulfills the criteria, that inquiry should still and must be made.
But, I mean, in many ways, that's not particularly surprising because we've got the general category of public assistance, yes, where needs may change, yes, and so you would expect reviews to check that someone remains in need of public assistance.
Yes.
But I'm not sure that shows that when one's looking at the discrete subset of disability assistance, that one's necessarily looking at a review in the same way. that depends upon whether, it almost begs the question as to whether that form of relief is intended to be permanent, decided at one point in time, subject only to the limited conditions in section 11A4.
But even then, you'd have to inquire into those conditions. If that is the limit of the review, because the physical condition does not change and the effect...
Sure, no, I accept that, but
there must
your proposition, as I understand it, is that there also has to be a review into the extent of disability.
Well, I can see why my lord asked the question, and perhaps it's taken me a little while to sort of get my head around that, but when you're dealing with somebody who's long-term disabled, if the condition is one that they might potentially recover from, one would expect there to be some sort of review depending on the circumstances of that individual. Since the duty of the board is to inquire into the circumstances of every recipient, then subject to the proviso where it is very clear that a person will never recover from the disability they suffer from, there may be other conditions, because disability is not defined, that they might over a period of time recover from. And that's why we say that to exclude review from the ambit and confine it only to the income factor may not be correct. But we accept that if, for example, you've got good medical evidence that a person is a paraplegic from which they will never recover, then that would be one of the circumstances the local board would have had regard to when they granted the award in the first place, and that may inform what should be reviewed going forward. But, my lord, the short point...
If it is a long-term disability, is there any reason why you couldn't get the public assistance year on year, whereas the review continues? Well,
I think I'm going to take the board to the regulation, and you'll see why I say this now. Can I invite the board to look, please, at... This is... If we go to the second set of regulations, this is at page 475. And it may be I'm answering my Lord Hamblin's question, which I hope I am. It's regulation 3.2 on page 475. And what it says is that public assistance shall be in the form of a grant for a period not exceeding 12 months and is subject to review. Now, there are a number of these regulations that apply only to disability, but the only one we will show, we say we can show, is regulation 3.1 and regulation 11A. Everything else is a generic regulation that covers all public assistance.
Well, it's difficult to think that 3.2 applies to disability assistance, because you only get it for 12 months under public assistance, where the structure of 11A suggests that it doesn't have that essentially periodical nature.
Well, the only way to resolve or reconcile the regulation with that section, we say, is that there must be a review, and or certainly the power to review under 3.2. Because otherwise there'd be no review of the disability assistance at all, even into the income factor.
These are the regulations made in 1997, is that right?
These regulations were made in 1997, and this...
So this is to operate with the 1996 version of the Act?
Yes,
where the Act itself, on its face, in the 1996 version, talked about permanent disability.
Sorry, I'm sorry.
Well, I'm not sure what then you can get out of Regulation 3.2, because if the Act itself, in its 1996 version, was talking about permanent disability, clearly 3.2 was not directed to a review of the disability element.
Well, only if it is only confined to public assistance and not disability assistance. And it's difficult to read 3.2 as
but it covers disability assistance, but only as to the conditions in section 11A4. So not the disability. There isn't a continuing review of disablement. There is a review to check every now and again that the income requirements are also satisfied.
Well, we would also say, because of the duty in Section 10 to inquire into the circumstances of a recipient, that could not prevent the local board from investigating into the issue of disability, because it doesn't say that. I think I understand the point my Lord Sales is making, but we would say that you can't read it as excluding a review into disability if that were appropriate.
But it would only, is this right? As at 1997, so when the 1996 version of the Act is in place, which clearly does condition the availability of disability assistance on permanent disablement, insofar as there is a check of the disablement element, is just to check that it remains permanent.
Yes. Yes, it would be to check that the condition, the disability, still qualifies her for the disability.
And even there, as you say, there will be some cases where it's not worth doing that because it'd be so
absolutely, because of the information that is available about that particular person. But what we say is it goes too far to suggest that there cannot be any review to anything other than what's provided for in 11A4 to confine it only to income, because there may be circumstances where a person is long-term disabled, but perhaps due to some radical or novel treatment, that they may recover from that disability. And the regulations are flexible enough to provide for such a review that if that change were to have occurred, the local board is not excluded from looking at the question of disability again.
But the regulations would have to be actually within the scope of the power. And if the primary legislation says the only matters you can take into account are as total income and conditions referred to in subsection 1B, then the regulations potentially aren't within the scope of the power.
Well, and that's another argument we will be making in relation to how one can make sense of the regulations, because it might be said that 3.1 is outside of the statutory power under section 16 if it's trying to confine the number of circumstances in which public assistance might be provided. But, my Lord, I am going to deal with all of these points, and I hope I've answered the question sufficiently for the moment. But can I invite the Board's attention back to 467, which is the body of the Act. And again, why we say that regular inquiries cannot be excluded and nor confined is because the local board appears to have broad powers under section 15. To carry out investigations even after a person has been granted public assistance. And all of these, we say, are pointers to there being a power to review even a person who is in receipt of disability assistance. And we say that it would be a misreading of the Act to suggest that you couldn't have a review, as the respondent has argued in their case, paragraph 25.
So is your case that a grant of disability assistance is always going to be for 12 months?
We would, as long as you satisfy the conditions, but there would have to be a review over a period of time.
But would it be for 12 months, or would it be...
Looking at the way in which the regulations are structured, if they apply in the way we say they do, then it is subject to a review. And the form of the grant
but what's the initial grant, I think, is the question.
Sorry?
I think my Lord's question is, what's the initial grant? Review, yes, we understand.
Well, the initial grant, as we understand it, would be for a period of 12 months.
Or even for disability assistance?
Even for disability. And so it is for that period, and then subject to review, assuming there is a review. If there's no review, then of course one can't say that the conditions have changed. And it may be that the local board takes the view that in this particular person who's received disability assistance, there need not be such a review, because there's no requirement to review it at a particular time.
12 months and is subject to review sounds as if it's speaking of 12 months maximum period, but with a review even within that period. And a new application if you want for a second year. It's just an ordinary meaning of 3.2.
Yes, I would accept that, Lord.
And on your interpretations you just gave it to us, if the initial grant of disability assistance is just for 12 months, there has to be a review,
Yes.
isn't there?
Yes, but
At the end of that period to see whether you get it for some more time.
yeah, but what that review is, it may be very, very limited. It may not be invasive at all, but there would at least be a review to monitor that that person is still qualifies for the grant. The reason I say that, my lord, is because there are a number of other provisions, for example, which say that even if it's not paid to the recipient, it can be paid to a nominee. Now, if you don't have the power to investigate or to review an award, even if it's disability, how do you know it's reaching the correct person? And this is why we say all of these are pointers to there being a review, but the nature of that review would depend on the recipient and would also depend on the circumstances that the local board has regard to.
So what on your submission is the difference between disability assistance and public assistance?
Well, my lord, we say that disability assistance is for people who are so disabled that they cannot earn a livelihood. And we say that it would be wrong to introduce the terms temporary and permanent in that question. We also say that the regulations make it clear that public assistance, as distinct from disability assistance, applies to various people who do not include those who are disabled. And to answer my Lord Borough's question, if you look, I think we're still at page 475, and we may be able to illustrate this in answer to your question. If you look at, we've taken you to 3.1 and 3.2. 3.1 we say relates to disability only, because it speaks to someone being prevented by some physical or mental disability from earning a living. That is very close in its terms to 11A1D. But then when you look at 3A, 3A then creates a series of other categories, saying that notwithstanding anything in 3.1, so those who qualify for disability, and Regulation 4.1, public assistance may be provided, and then it creates a recipient of a senior citizen's pension whose spouse is unemployed, etc. That's in A. Then in B, a person whose spouse is deceased. C, a single parent. D, a child who has a physical or mental disability. And then it goes on to 4, subsection 2, which is referred to. Notwithstanding Regulation 3.1 and Subregulation 1, public assistance may be provided to meet the needs of the following, and then it speaks to a child living in a household where that household may qualify for public assistance. B, a child who the local board may deem necessitous in accordance with guidelines issued by the board from time to time. And C, a person who is the spouse of a person or cohabitant who is currently in prison. And then you go to subsection 3 of that part of the regulation. Notwithstanding Regulation 3.1 and Subregulation 4, public assistance may be provided to meet the needs of a woman where she is a person referred to in Subregulation 5A or B, which doesn't apply here. And because I'm dealing with this, those are the further categories of public assistance, as distinct, we say, from disability assistance. And then when you go to Regulation 5.1, again, another pointer, Regulation 5.1 makes it clear when a medical certificate from a government medical officer would be required. And it draws a distinction between an application for a child in Regulation 4.2. An application for public assistance shall be supported by a medical certificate from a government medical officer and forwarded to the chairman of the local board in the local public assistance district, etc. So it's perfectly logical and perfectly reconcilable to look at this regulation, we say, and look at 11A1D and show that certain parts relate specifically to disability. So this is Regulation 3.1, and there are other parts of it that relate to public assistance broadly and different types of public assistance broadly. While I'm on the regulation, if I can invite the board's attention to...
But, just on that, where does one get the review function?
in relation to other types of public assistance.
Yeah, and indeed the timing. Does Regulation 3.2 not
Well,
apply?
we would say Regulation 3.2 provides for review for all forms of public assistance by virtue of the definition in the body of the Act, because it makes it fairly clear public assistance, insofar as that term is used in the Act, covers everything unless there's a specific distinction in relation to disability assistance. 3.1 is disability assistance, and the second part of that is in, this is section, so it's page 481, my computer's catching up, and this is section Regulation 11A. So this is the only other regulation we've identified that specifically would relate to disability assistance. And this was introduced in 2004.
What's the page number?
Sorry, 481, and it's Regulation 11A.
But,
Sorry.
I'm looking at comparing 11A back to
465.
3.2.
Yes.
Your case, as I understand it, is that because in 3.2, I'm sorry, I'm taking a little time to get back to it.
475, I think.
Public assistance includes disability assistance. You only ever get a grant for a period not exceeding 12 months.
That is as we understand the regulation.
Then how does that fit with 11A?
This is 11A4.
11A4,
Yep.
if it applies to disability assistance, it clearly does apply to disability assistance. I'm looking at 11A1.
Sorry, 11A1,
On
yes.
page 481.
So Regulation 11A1.
Yes. Sorry, regulation.
Sorry, 481.
I'm not going back to the section.
No,
Forgive
sorry,
me. My
yep,
fault.
I'm there.
Now, that appears to contemplate somebody's going to be in receipt of disability assistance for more than 12 months, in which case it gets discontinued.
Yes.
Is that a pointer towards 3.2 not being about disability assistance?
To say that it would only relate to disability assistance.
No. Is it a pointer to 3.2, Regulation 3.2, not being about disability assistance?
Well,
and therefore, the provision for only getting it for up to a year and for review not applying to disability assistance. It would all be, if that's right, it would all be in line with disability assistance being an altogether more permanent animal.
I would accept that it would be in line with that, except that I'm not prepared to, well, I'm not prepared to. It's my submission that, in fact, there must be a review, and the provision, the machinery for that review is Regulation 3.2, which applies to disability assistance as well, because public assistance is broadly defined.
Yeah, yes, I understand that.
So,
But subject to a contrary intention.
subject to a contrary intention. But otherwise, and I'm going to take the board to this now, we have tried to reconcile any conflict between the Act and the regulation, which we say we are able to do. We have said that in our case that Regulation 3.1 in itself could be ultra vires the Act if it seeks to confine the form of public assistance, because that is not something that is permissible. But when you look at 11A2, and this is the section 11A2, which is at 475. Sorry, no.
No, it's
465.
Yeah.
And 465, 11A2, states, notwithstanding certification pursuant to Section 1D, the Director of Social Welfare may, if he sees fit, refer the applicant to the Chief Medical Officer for assessment and certification of disability. So this is vesting in the Director of Social Welfare further powers to investigate into an application for disability. even if you've got the certificate from the medical officer saying, well, you may qualify.
But that just looks like a sort of appeal to a superior medical officer.
At the time of the claim.
At the time of the claim.
Rather than during the currency
Yes,
of the grant.
and we accept that. But what we say is that when you actually look at the requirement and the power to review, insofar as this may be relevant, it doesn't speak in terms of permanent disability. There's no reference to temporary or permanent in any of these provisions that speak about disability.
But in relation to subsection 2, I assumed that 11(1)(d),
Yep.
all you needed to do was to obtain a medical certificate,
Yes.
basically from your general practitioner. Is that correct or not?
It has to be
Medical officer.
a medical officer.
A medical officer, so a GP or a physician or whatever.
Yes, it's. I'm assisted by Mr. Tackle.
Yes, yeah.
Medical officer is in fact a designated person at the hospital, so not every doctor, I think, would fall into that category.
Right. But
be
a
honest.
fairly broad category
Yes,
of people that you can go to.
a number of people would probably
And if the
fulfil that. Correct.
those charged with administering the system aren't terribly happy with that certificate,
Yes.
they can go off and get their own
Correct.
examination.
Correct.
That's all done at the time.
But insofar as it may assist with the question of interpretation, it doesn't speak, this section does not speak in terms of temporary or permanent. It's simply looking at the effect of the condition.
But what is the medical officer, or the chief medical officer, as the case may be, certifying if the structure is that they look at the individual once without a proposal that they do it, after set periods? Are they not looking forward and making an assessment of their permanent state? What else could they assess?
They would have to have an assessment which covers that question, I suspect. Can you define it in those terms? Is this person likely to recover? Is it going to be long term? Is it predictably going to be shorter term? But however you phrase that question, my lord, what we say is that the certification of disability is not viewed in terms of temporary or disabled, the way in which the Court of Appeal sought to resolve it. Because the question then arises, well, what is permanent disability versus what is temporary disability? And that's the problem. Someone like Ruth Peters, who suffered from the condition that she did, when you actually look at the length of time when the various medical certificates were provided, what's very clear is that well into 10 months of suffering from that, doctors were still certifying that she's going to need a review in 12 months' time. And she's still 90% disabled. When the evidence was filed by her father, which was, I think, 10 months after the first certificate, he indicated that there had been no material change to her condition at that time. And this is the problem in the Court of Appeal's interpretation, saying, well, there is a distinction under the Act, under the regulations, between temporary and permanent disability. We say that that just doesn't arise. The simple question is, was she so disabled she couldn't earn a living? Answer, yes. Maybe there should be a review, and that review should take place in 12 months. And because of the combined effect, we say, of Section 10 and Regulation 3(2), that creates the machinery for the local board to carry out a review to somebody who's in receipt of a disability grant, if that is necessary.
I have the impression, but I'm trying to find the particular provision, that according to the regulations in place at the time of the changes in 1998, so the regime as it had existed up till then, it was clear that what a medical officer would be certifying would be permanent disability.
Yes,
That's
but
what
prior to the amendment, prior to the Act being amended, can I...
So in answer to my question,
Yes.
what are they to certify? They would look at the regulations and they would get an answer to that. They have to certify whether it's a permanent disability or not.
It may be worthwhile looking at the certificate they actually filled out, my lord, because it shows what it's at page, I think it's page 288.
Well, just before we go there, can you help me with the provision in the regulations that say that certification is of permanent disability?
Well, that's the thing. It's not in the regulations, it's in the form.
Yes.
Right.
That's the problem. So there's not even, and I'm going to answer my Lord now because I think this is the right time. Firstly, it's been removed from the Act. Although the regulations were not amended, what wasn't amended was the form. The actual regulations proper, regulations 1, 2 and 3, don't say anything about permanent disability at all. And if I can invite the board's attention now to that, if you look at 465,
Just to make sure I can orientate myself around
Yes.
it, the pre-amendment section 11A, whereabouts do I find that in the budget?
it is in, I think you will find, I think it is. I think Mr. Strang did put it in. There is a version of it. I'm afraid I don't have an immediate reference to it, but I think there is a, do you have 496, 496, the,
Thank you very much indeed, thank you.
thank you, I'm very grateful. So if you look, sorry, lost my page now.
And I'm so sorry, I just want to be clear. So page 496 is what, the 1996 version of the legislation?
Yes, this is an earlier version of the legislation, which I think included the requirement of permanent disability in section 11A. Although I hasten to add, I'm not relying.
Permanent or likely to be permanent, which at that time covered the problem of the person who makes an unexpected recovery.
And in a sense, likely to be permanent doesn't really add very much to it because it would always be a civil standard of proof as to permanency.
I think that's right. I think the difficulty with the word permanent, even in the earlier legislation, is that it's difficult to define because permanent would have to cover long term if one wants to use that word. But we say that whatever the previous legislation said, it matters not, and it matters not because it was changed. The relevant Department of State and the court had to look at what section 11A1D says now and what it requires. And if it doesn't use the word permanent or temporary, then that's clearly a deliberate change in the law, and so you look to the wording used to determine what the test is. Insofar as it has been changed, it has removed any requirement for permanence in the way in which that term was used before. There is no other way we say that that can be read. And we say that even though the form was not changed, it is of significance if you look at page 469, and this is the the regulation we complain about. 469 is the prescribed form regulations. Now, 2 points to make in relation to this. As we've argued in our case, this is made under section 11B. So we say that on the face of it, it's ultra-vires anyway, because there's no power under 11B to create a regulation. That is only section 16. But even if it had been made under the requisite regulation, when you look at the regulations proper, 1, 2, and 3, 1, 2, and 3 don't actually impose any requirement for permanent disability. Regulation 3 speaks to the form required to be prescribed under 11B, and then when you look at the form, this is the very next page, under the heading qualifications, it's in letter D at the bottom of that you find government medical officer, must specify government medical officer as being permanently disabled. And that's the only place you find it in the regs.
470.
Sorry, 470, and it's lettering D under the heading qualifications.
Yeah.
And what the judge did, we say correctly, is to reconcile the conflict between 11A1D and the form, and she simply expunged the word permanent, permanently. And that, we say, was the correct resolution, because it now brings the form in line with the Act. But we say the point can be made a little stronger because this is merely a form. I mean, to adapt the phrase, there's no such thing as form over substance. The substance is found in the Act, the substance is found in the regulations proper, neither of which impose any requirement of permanence. And so the fact that it's left in the form cannot survive the amendment.
Well, I can understand that the form should be brought into accordance with the Act, but that begs the question, what does the Act mean?
Yes, and this is why, absent a definition of disability, you cannot then suddenly introduce, by virtue of the secondary legislation, it must be defined through the lens of permanence or temporary.
But the form was in accordance with the Act prior to 1990.
Prior to. And if we can invite the board's attention now to section 16. So this is the power to make regulations. This is at page 467. This is section 16.1. The minister may make regulations for carrying the purposes and provisions of this Act into effect. And we say that when you have to read the legislation on an always speaking basis, the question is, what does it say now in light of section 11A(1)(d)? And so the minister, whatever the regulations may have said when previously made, it has to it has to be made for the carrying and purposes of the provisions of the Act into effect, which again we say contains no requirement of permanence. And in terms of scope of power, and I suspect these principles are quite well known, and I will not dwell on them. If the board turns now, and I'm going to turn the board to some extracts in Benyon, which we say are relevant. If you look at page 789, the board has considered the question in the case of Utah Construction versus Pataki, and the quote that has found its way into Benyon is to the effect that, and this is at the top of page 789, the result is to show that such a power does not enable the authority by regulations to extend the scope or general operation of the enactment, but is strictly ancillary. It will authorise the provision of subsidiary means of carrying into effect what is enacted in the statute itself, and will cover what is incidental to the execution of its specific provision. But such a power, and perhaps this is the important part, will not support attempts to widen the purposes of the Act, to add new and different means of carrying them out, or to depart from or vary the plan which the legislature has adopted to attain its ends. And so read as the Act is now, with the regulations as they are now, the regulations cannot be decisive in construing section 11A(1)(d). And I say regulations, I mean the form. The form cannot be elevated in that particular way. And we say that the approach, that's again a strong indicator as the approach in this case, that the regulations, insofar as they purport to add new or different means of carrying out the Act into effect, that it cannot be applied in that way. And there is no Henry VIII power insofar as that does feature in some pieces of legislation. The short point being, we come back to it, I'm sorry for repeating, there's no requirement of permanence. We have relied on the case of Vibixa, which we've quoted in our case. I wasn't going to take the board to it, but it is at page 631 if the board wishes to note it. But essentially the point is this. The court has to proceed on the basis that the preamble to a statutory instrument sets out all the statutory enabling powers that are necessary for its validity. Well, as we've already made the point, this was made under 11B. which doesn't create a power to make regulations. And so the board could, if it wished to do so, simply determine that because it has been made under the wrong section, it is ultra-vires in any event.
Is Section 16 the only regulatory power making?
Correct. In this Act, yes.
In the Act.
That is correct.
And so if you read 11B,
11B doesn't create that power. It simply says, you know, this is how this would be what you would do if the form is provided. But it certainly cannot be read as creating a power to alter the provisions of the Act. And we say that with...
it wouldn't take a great deal of intelligence to move on from 11B to Section 16.
No, and that is why we've been very careful, because although we recognise that it's made under 11B, that's very clear, the evidence made that out. We also know that the courts tend to approach regulations in a way that tries not to invalidate them. And so the only way to make sense of it, we say, is that if it was to be treated as made under Section 16, still doesn't survive because of the arguments we've made about what it actually says. It doesn't create a regulation introducing permanence. And I've taken the board...
But if we were to treat the reference to 11 at the top there as a clear error, and it should be 16, and if we were to say that there is a requirement of permanence in relation to disability assistance, then everything would make a coherent picture, would it not?
Except that it's not in the Act, and so wouldn't be coherent, we would
If we construed.
If you construed it, but we are urging the board not to so construe it, which is the argument.
But you're asking us to fight against an overall coherence on the basis that the Act clearly doesn't allow us to do that.
We say, well, yes, but we say we can smooth it over a bit more than that. What we say is that the Act having been changed, the clear intention of the legislature was to apply a new criteria. So someone who is so disabled they cannot earn a livelihood. That's a simple question. It is not ambiguous. And the way in which the Court of Appeal appeared to approach it was to create the ambiguity by looking at the regulation. But if the provision is clear, and that's the only question to be asked, you don't need to look at the regulation, and the regulation is not consistent with it. We also say, my lords, that insofar as the Court of Appeal tried to draw a distinction between disability and public assistance, and that public assistance could be available for people who were temporarily disabled, we say that that's wrong. We say that disability assistance is available for anyone who fulfills the criteria. We also say that it's very clear that both types of grant are available to a single candidate. And if I can take you back to the form, which is at 472, the form itself seems to cater for this. And it would make sense, because there's no reason why a person could not fulfill both criteria. And if you look at paragraph 29 on page 472, the form itself asks the question, are you in receipt of public assistance? So you may very well be in receipt of public assistance, and then suddenly you also fulfill the criteria of disability assistance, and then you could make that application as well, which we say is perfectly logical.
But you may be in receipt of public assistance, not through disability, but from other...
Correct, but we say that this is where, in resolving it, in making the regulation make sense, disability relates to those who are disabled, so disabled they cannot earn a livelihood, and the other forms of public assistance relate to other things. And you can qualify for both if you fulfill the criteria. But ultimately, my lords, any interpretation, we say, of delegated legislation still has to adhere to what we say are the general principles. And as Benyon explains, this is at page 790. And it's the middle of the page under the heading Interpretation of Delegated Legislation. Paragraph 17, the general principles of interpretation that apply to acts apply equally to delegated legislation, and this is the important part, but with the additional consideration that since delegated legislation derives its authority from the enabling act, it must be interpreted in light of that act. And we would say that applies even when the act is amended.
It's an interesting situation, isn't it? Because usually you can use delegated legislation if it has an association in time with the primary legislation, made at about the same time as the primary legislation. And here we've got a situation where you have delegated legislation, which was valid, which was made before the Act was amended.
It would seem, as I'd like to show my lords, that Parliament in Trinidad and Tobago recognised that this situation might arise. But to complete this reference to Benyon, if the board goes to the bottom of page 790, under the heading Delegated Legislation to be interpreted in light of the Enabling Act, you see there similar commentary by the editors. In order to construe delegated legislation, it is of course necessary to consider the Enabling Act carefully and consider the delegated legislation in light of that act. And then the approach we say...
The same point as Lord Stevens has made applies. You accept that the form regulations were intra vires at the time that they were made. So they're perfectly valid regulations construed according to their ordinary language.
Under the original Act.
Under the original Act. And they form part of the context in which one interprets the amendment, do they not?
No, because the amendment jettisons the language that mirrored the language in the form. And so Parliament, taken to know the law, must understand that if it amends the Act, then the Act would take precedence over subsidiary legislation made by the Minister, even if it remains unchanged. And this is why we've taken the board to this particular extract in Benyon, because it goes on to say, function of the court is to determine the legal meaning of the words used in the delegated legislation, assuming the board is prepared to construe what's in the form as part of the regulation, and then goes on to say the Enabling Act forms a crucial part of the legislative context in which those words must be construed, and it may well affect their meaning, applying the principles discussed below. And so, in further answer to my Lord Sale's question, even if the amendment has been made, even if the Act the regulations were in line with the Act before, the approach is still the same. You look at the regulation as to how the Act is now. And then the last paragraph of that, the courts will, for example, proceed on the assumption that the legislative purpose underlying the delegated legislation is consistent with that of the Enabling Act, and we say that that also applies when the Act is amended. My Lords, the bottom of page 791, and this is why we've sought to resolve the conflict between the Act and the delegated legislation. Under the heading Interpretation in favour of validity, Benyon states, where possible, a provision of delegated legislation is interpreted by the courts in a way that avoids the conclusion that the provision is ultra vires. This is on the basis that the person entrusted with the power to make delegated legislation may reasonably be expected to intend to act within the scope of their powers. And we would add to that the scope of their powers in the Act as amended. So we say that the way the board should proceed, as the judge proceeded, is that the minister, whatever he may have said at the time the original regulations were made, was not intending that those regulations would run counter to the amendment to the Act. And so even for this additional reason, we would say that the word permanently can be expunged and should be for the Act and the regulations to be interpreted validly. Now, my lord, this, as far as we can tell, this is the first time this type of point has arisen, certainly from Trinidad and Tobago. And when we looked at the approach of the respondents to look back at the history of the legislation, I've tried to answer the questions in relation to those as they've come. We say that the Parliament of Trinidad and Tobago seems to have catered for this situation in the Interpretation Act. And if I can take the board to the Interpretation Act, we've given the board the extracts that we rely on in Volume 1, but the whole of the Act is available on the electronic bundle in Volume 2. And if I can take you to page 515, this is the Interpretation Act now. This Act has retrospective effect, so it applies to everything that passed by virtue of Section 2.1, both before and after this particular piece of legislation was enacted. And so with that in mind, if the board turns to page 516 and looks at the rules of construction, beginning with Section 10.1, we say that when we apply the Interpretation Act in conjunction with the principles the judge applied, which is consistent with what I've taken the board to in Benyon, it is now possible to resolve the conflict, to remove the word permanent. So 10.1, the always speaking doctrine, is put onto a statutory footing, and the law has to be interpreted according to its true spirit, intent, and meaning. Pausing there, with someone, as we know, like Ruth Peters in the condition she was, it could not have been the intention to exclude her from the ambit of disability assistance.
Well, she is within the ambit of disability assistance, but under a slightly lower level of it.
Well, that's if you construe the Act as creating two types of disability assistance. So one which is disability assistance grant and the other which is public assistance for people who are so disabled they cannot earn a living. But that's the problem, because the wording of both 11A1D and the provision the Court of Appeal took into account, Regulation 3.1, are very easy to reconcile as only referring to disability assistance, because I can't see how you can be so disabled you cannot earn a living in 11A1D and so disabled you cannot earn a living as something different in Regulation 3.1. And the culprit is this word permanent. If you
Regulation 3.1, you don't need to be a citizen of Trinidad and Tobago. And there are a whole lot of other conditions that drop out of 3.1.
There are other conditions, but in terms of the application of Regulation 3.1, it is not in conflict with 11A1D because of the words used, so disabled you cannot effectively earn a living.
Well, just as a matter of fact, as opposed to statutory interpretation, there is public assistance for temporary disability in Trinidad and Tobago.
Well, this is the interpretation that's been given. Yes.
That was a slightly different question. That is, there is such assistance.
Well, my lord, that is the approach that's been adopted, and they want to use the phrase temporary. But and I know this is not necessary to resolve in this case. But when you actually look at the Act and the regulation, there is in fact no basis to create a different form of public assistance at a lower level for someone who fulfills the criteria in 11A1D. It makes no sense. It makes more sense to say anybody who fulfills that criteria for disability allowance gets that. This is why we were keen on the review, if one could construe it as potentially resolving itself in some years in the future. And then everybody else gets public assistance subject to other criteria. And it's perfectly logical to resolve it in that way. And we say consistent with the approach to read the regulations in a way that doesn't render them invalid. But coming back to it, my lord, if I may, Section 10.1, we say that the true spirit, intent, and meaning of Section 11A1D is to cater for people like Ruth Peters. For the reason, and I haven't taken the board to the medical evidence, but it may be worth looking at that now, if I may. I won't come back to it. It's page 288. So page 288 is the beginning of the correspondence where she submits her application, and it's the second paragraph. In view of this, she has applied for a disability assistance grant. In order to process this claim, it is necessary to obtain a medical history on the applicant. And then the first filling out of a certificate is at the bottom, which simply puts prognosis as clinical assessment after 1 year to note if improvement. The point we would make, there's nothing there saying it's temporary.
So can I check, does this certificate reflect the form appended to the form regulations?
No, this is an earlier part of the process where the applicant has to fill out these particular sections.
So is this form taken from regulations at all, or?
No, it appears to be a generic form. It's not actually the prescribed form regulations. Sorry, I think my Lord means is it a form appended to the Act? No, it's not.
Right, so it just happens to be a form that
has been used by the
officers
department.
Use,
yes.
Or this hospital uses.
No, this is issued by the Social and Welfare Division. You'll see from the stamp at the top right-hand corner.
So this is after they've received whatever the medical officer.
No, this is where they have made the appropriate application to the department, and then they are. This is a document that is provided to the applicant to take to the doctor. As you'll see, it's titled "To the Doctor" at the top, and the doctor then has to fill out the lower section.
Oh, I see. So the handwriting is what the doctor.
Yes.
has.
Yes. Correct.
Okay.
Yes.
Sorry, that's what was confusing.
I apologise. I should have made it clear. And then the same point, but now they are now giving further documents for the applicant to fill out. Is at page 290. It had a somewhat unhappy history of the father going to and from the office to get forms, but that is why there are so many. But the importance is when you look at what is at 290, this is the medical officer's report for disability assistance. The medical officer is making clear, disabled from earning, yes, this is the middle of the form, percentage of disability 90%, whether disability is permanent, doesn't say it's not permanent, simply says 1 year pending clinical reports, because there had to be a review of her condition.
And so, again, this is a form given to
Correct.
the applicant, or
Correct.
applicant's father.
That's right, and she has to then take, or her father took it to the relevant medical officer to fill out. And it happens again, then there's the...
Would the first form be sufficient for public assistance and the second form for disability assistance?
The first form is an application for disability assistance. It's actually specified in the second paragraph of the letter on page 288. In view of this, she has applied for a disability assistance grant. But then, as I say, there was a bit of toing and froing. Page 288 is the certificate I've just taken you to for disability assistance. Then at page 290, this was another form where they said, well, you're not permanently disabled, now you should apply for public assistance. But when you look at the form for public assistance, it asks the same questions. Whether disabled from earning, yes. Percentage of disability, 90%. Probable duration of disability, 1 year. Well, that's the probable duration, not saying that it won't continue thereafter. And the final one is when they presented that form to the department, they then said, no, you should apply for disability assistance. So they came back and they filled out the form at 294. And 294 is the final form before the father became extremely frustrated and spoke to attorneys. And 294 again confirms.
Read what it says there. Whether disability is permanent.
1 year.
Whether
1 year.
Whether disability 1 year.
What's the word before one?
One.
It's 1 brackets.
Oh, I see.
One brackets 1.
Sorry. It's just very indistinct on my call.
Yes.
Yeah, there it is.
Not at all.
I mean, is it part of your submissions that the medic should have filled in, yes, it's permanent?
Well, my lord, The short answer to the question is I think it would depend on the opinion of the medical officer. If they are being asked whether the disability is permanent, then there has to be a review. Then they wouldn't say that it will or will not continue after 1 year. They would say, as they said in the earlier versions of the certificate, there has to be a review. But assuming, and this goes back to this whole question about review, although I don't want to go back to it, but if you look at the bottom of this particular form, page 294, there is a note to the medical officer. The object of this report is to target persons who are mentally or physically handicapped with a disability that is permanent or likely to be permanent. And the point is, they're not saying she's not.
Well, I mean, they are, because that note supplements the question which is asked whether disability is permanent, and they did say it is.
Well, my lord, we would say, knowing what we know about the disease, knowing what we know about the effect on the applicant, that it cannot be read as the medical officer saying it's not permanent. In fact, it's very clear there has to be a review. They can't say. And they couldn't say, no doctor could say the condition, the disabling condition could not be permanent. They could only say there needs to be a review because of what science tells us about that particular condition.
Right, but he's not willing to say positively it is permanent.
No, he doesn't use the word permanent, but neither does he say it's temporary.
The note to him is asking him, is it permanent or likely to be permanent?
Yes.
And he hasn't said yes to that either.
No, but as I say, he's between a rock and a hard case, as it were, because he can't actually answer that question definitively because there has to be a review. And then it brings in the question, what is permanent in the context of this condition? It could be permanent, it could be long-term. And the doctor is not able, on this standard form presented to him, to provide more information than that.
So it isn't part of your submissions that actually she ought to have been classified as suffering from a permanent or likely to be permanent disability?
Well, we would say, my lord, that on the information that was available at the time, one could not answer that question to say whether it was permanent or not. One could only say it was long-term. And modern definitions of disability, as the Minister Ramsaran indicated at the very beginning of my submission, it would be sufficient that you are so disabled you couldn't earn a living at the material time the question is asked.
I mean, in effect, as I understand, your case is that this form is asking the wrong question.
Yes, correct. Where the form comes from, again, it doesn't find its way into the regulations, but this is a form that has been used. So it might have been better to simply say provide a medical report, in which case the doctor would not have been confined to the headings. But, my lord, I don't want to not take the board to what we say is the decisive law that helps the board resolve it to uphold the judge. If I can take the board back to the Interpretation Act, and this is at page 523, which we say provides the answer when looked at in total. And what subsection 3, this is section 29, subsection 3 states, without prejudice to subsection 2, where a written law repeals or revokes a written law and substitutes another written law, therefore, by way of amendment, revision, or consolidation, A, all statutory instruments or statutory documents made, issued, confirmed, or granted under the old law, and all decisions and authorizations, directions, consents, applications, requests, or things made, issued, given, or done thereunder shall, insofar as they are in force at the commencement of the written law so substituted, and these the important words, and are not inconsistent therewith, have the like effect, and the like proceedings may be had thereon, and respective thereof as if they had been made, issued, given under the law so substituted. Those words, and are not inconsistent therewith, make it clear, beyond any doubt, we would say, that the regulations, even if they are unamended, have to be brought in line with the Act itself, because they are inconsistent insofar as the form is treated as part of the regulations.
Well, that depends. That begs the question as to what the Act means.
I hope I've addressed that, my Lord. It's not to go back to it, but we say that the only question is, are you so disabled you cannot earn a living? The answer we say for the applicant in this case is yes. That's the only question to be asked. If the regulations are inconsistent with that, which the form certainly is, then 29.3 makes it clear the form cannot survive the amendment to the Act. And the judge's approach was correct to expunge the word permanently to preserve the validity of the regulations. And my Lord, finally, on regulations, there is another indicator in the public assistance regulations that supports this view. If the board can go to page 482, this is the last section, section 14, of the public assistance regulations. This is page 482. And this appears to be an original regulation, which was in the original 97 making of this instrument. Every form prescribed by the Minister or approved by the Board in accordance with the Act immediately before the coming into operation of these regulations shall remain in force, and these the important words, or be used with such modifications as may be necessary until replaced in accordance with the Act. And so the clear contemplation of the public assistance regulations is to read any form that is used to be in conformity with the Act. And certainly if there had been any conflict in the forms that had then been in use, they would be read in line with the Act as amended. And this Act had been successively amended since 1951. So the super-locking effect, we say, from Regulation 14 and Section 29.3 of the Interpretation Act puts beyond doubt the judge was correct in removing the word permanently. And the regulation is thereby saved. How many have you done? My Lord, just bear with me for one moment. There are various other definitions in the Interpretation Act which the Board may be assisted by. So, for example, it provides what may be fairly standard definitions as to what is a statutory instrument and so on. I can give them to the Board if needs be, but they are there in the earlier sections. My Lord, just bear with me. Just looking forward in my note, I think I've answered the questions that I thought I was going to be dealing with later, but is there anything else? Okay. My Lord, I'm helpfully reminded by Mr. Taklal Singh that the way in which 11A1D is to work, subject to fulfilling the criteria, the local board should make the decision. That actually is the import of the section. What happened here was a summary decision was made by the welfare officer to say that there's a requirement of permanence and this application will not be processed. And then all of these forms start to be given. That, we say, she was not open to her to do.
Well, it was if the Act required permanent disability.
Well, we say that when you look at 11A1D, it's the local board that has to make that decision. There is no separate process. They have to look at the application as is.
Well, however, I mean, suppose somebody put in a form that just plainly showed on its face that they didn't comply with any of the statutory requirements. Are you saying that would still have to go before the local board? Why can't the officer screen it for obviously hopeless applications?
If it were in the Act, my Lord, I would agree with you. And that may very well be a practical way to resolve hopeless applications that simply do not fulfil the criteria. The problem, however, is illustrated in this case. If it is for the welfare officer to make that determination, then the opinion of the local board, who ultimately have to make the decision, never get to make the decision.
But I mean, Section 11A1D says they're only allowed to make that decision if there is a relevant certification by a medical officer. And I appreciate you contest whether this was the right judgment, but the assessment was there wasn't a certification. So what's the point of...
Well, certainly that's the view she took on the medical evidence that was presented to her, but for the reasons we've given, we say that was plainly wrong. My Lord, one final matter which just deals with this issue of medical certificates. In the regulations, this is Regulation 5 of the Public Assistance Regulations. It's page 477. I think I may have taken the board to this already. Save for an application in relation to a child, it looks like a medical certificate is always required for any kind of public assistance. And that may explain the two forms we've got, which are virtually identical for disability and public assistance. But it would be wrong to proceed on the basis that you didn't need a medical certificate from for other types of public assistance. It may be that there are other matters a government medical officer is supposed to address, but the only forms are the ones that I've taken the board to in this particular case.
I can't quite see the sense of that if one's looking at categories of, for instance, I can't remember them all now, but single parents.
I agree. Well, the way this appears to be one of the original provisions under the original ordinance, certainly an earlier version of it. But it seems that there has always been a role for a government medical officer who may have had broader powers at an earlier time. But certainly that appears to be the position. My Lords, I have addressed you on, I think, all of the legal submissions we wanted to make. Can I assist the board further on anything?
No, thank you very much, Mr. Harrell.
Thank you.
We're going to retire for a few minutes to see where we've got to, and we'll resume the hearing as soon as we can. Mr. Strang, Mr. Harrell, we've considered the matter as you've noted outside, and we don't need to call on submissions from you. Thank you, Mr. Strang. We are nonetheless grateful to both parties for their carefully presented written and, in Mr. Harrell's case, oral submissions. And we will take time to give the reasons for our judgment and let you have them as soon as we can.
My Lord, can I mention one matter? We did send through a document which it's not necessary for me to take you to. The judge referred to Hansard extracts in her judgment, but the board didn't have that available. It does now on the email.
Thank you very much indeed.